now, because we waited for staff to get together, is almost 10:24, something like that.
Yeah.
All right, and so we waited sufficient time. We don't have any messages, and she's not in the hall. I do have a bench warrant that has been presented to the court. The court will sign it, and is the amount that's owing the $3,679.68, or is that a percentage?
That's 10% of the total judgment amount, which was $36,796.77.
And is that just your practice, or?
Yes.
I mean, I'm happy to put in the full amount.
That can, yeah.
Okay.
I'll leave it to your discretion.
That's what I do. What's the amount?
So the judgment amount was $36,796.77.
Rationale is if she's able to post the 10% or whatever it is you did, we're never going to see her again. I'd rather have the whole thing and then we get something worked out and she shows up. So I don't like the slow bleed. I like the quick burn.
Yes, I appreciate that. Yes, sounds good to me.
All right. This has been signed and you will get your copies in just a moment. Anything else for the record?
No.
Thank you for your time this morning.
Thank you.
This is docket 25727 FC, People's State of Michigan versus Charles James. Counsel, your appearance for the record.
Good morning, Your Honor. Jennifer Lawton on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, public defender on behalf of Mr. James.
I will get it in a minute, Mr. Freeman. It is unfortunately not working at this time, so I have to go reset it real quick.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And you've had an opportunity to speak with your attorney in regard to sentencing?
Yes.
And you recall that you pled to count 1, criminal sexual conduct, 2nd degree, person under 13, defendant 17 years or older, punishable by 15 years?
Yes.
All right, let's just go off the record a moment while that gets reset, counsel.
My thanks to the court.
All right, we are back on the record. Thank you. And on behalf of the people, are there any corrections, additions, deletions?
Just one correction, Your Honor, under the pre-sentence investigation updated report under evaluation and plan. In the second paragraph, the last line in that paragraph says scheduled for sentencing on 1/15/25. That should be 1/16/26.
I'm sorry, just looking for that, so. Under what section, there's like.
Under evaluation and plan,
Yeah. Because it's an update, it's mine's a little out of order, all right, I see, okay, I see the defendant scheduled to appear for sentencing 1/15, so I'm changing that to 1/14/26. And then that would also be on the, is that on the basic information sheet?
I think it's correct on the basic information sheet.
Double check. It is correct. And then I'm just gonna double check the instant offense unless you already did that as well. It's correct there too.
Yep.
All right, thank you. Counsel, on behalf of the defendant, is there any correction to the body?
Your Honor, I typically do, but I have no additions, deletions, or corrections to the body of the report.
And as to the guidelines?
Guidelines are correct, Your Honor.
Agreed, Your Honor.
All right, thank you. Do we have a victim here who wishes to address the court?
No victim present at this time.
All right, you may proceed.
Thank you, Your Honor, on behalf of the people and on behalf of the victim. This is obviously an egregious case. The defendant sexually assaulted his own daughter, which is just beyond comprehension. In speaking with the victim previously, as well as her mother, they really just want to be able to put this behind them and move on. It's my understanding that the defendant's parental rights have been terminated at this time. And so in looking at the case overall, in having conversations with the victim and her mother, I do believe that we did reach a plea agreement that works for everyone. So I would ask that the court follow the plea agreement and sentence the defendant to a fixed minimum of 60 months.
Thank you. On behalf of the defendant?
Yes, Your Honor, thank you. The pre-sentence investigation report indicated that my client had told the probation agent of his progress while he's been incarcerated in terms of the classes that he's been taking and so forth. He did not have evidence of their successful completion at the time. He did bring those documents with him to sentencing if the court or the people require evidence of his completion of those classes. Beyond that, I too would respectfully move the court to sentence my client consistently with the agreement of the parties. There was a good deal of negotiations that went on here, as was previously indicated. The victim and her mother were both made aware, and I would echo the sentiments of the prosecutor and ask the court to follow the recommendation if that would please the court.
Sir, anything you want me to know?
No, ma'am.
I see a lot of crime. There very little that turns my stomach. This kind of case turns my stomach. How you could do this to a girl you were to protect is not negotiable, not understandable. You have ruined your daughter. It's going to take her years to get over this trauma. Her mother is to be credited for removing you from the child's life and believing her daughter immediately and taking action. You, after you raped her daughter, fled through the window. There's a lack of accountability here. I don't like this plea agreement, and I want to state that for the record. The only reason that I am accepting it is because the victim needs to move forward in her life, and putting her through a trial will only add to the trauma that she is going through and will go through probably for the rest of her life, and you caused that. A little girl should be able to get out of the shower without her father coming in and raping her. without her father restraining her, without her mouth being covered when she screams for help. She should not be forcibly raped. And there is no doubt that this was you, sir. Not only have you pled, but the DNA proves it. And this is extraordinarily troubling to me. They got the right man. The behavior is incomprehensible, inexcusable, and not to be tolerated. So again, you got very, very lucky, because I am not a judge who takes this lightly, but I do hear the cries of the victims. I do understand the trauma of going through a trial, especially for such a young girl. So I'm only honoring this plea agreement because although she is not here, I suspect the trauma is too much for her. And my understanding was she was going to provide, or the mother was going to provide a more detailed victim impact statement. I don't see it here. Did you provide it?
I have not received any additional statement, Your Honor.
Okay. What is compelling to this court is that the mother stated she believes she has made the proper steps in regards to her daughter and her safety. This is something they have never dealt with before and hope to never deal with again. They are now moving forward with no anger or hatred anymore, and they will accept whatever decision the judge decides. As much as I could decide to go to trial on this, I'm deciding in favor of the little victim who needs to spend time in treatment, not in trial. I hope through time she understands that prosecutor's office and the court heard her cries, unlike her own father, that we wish her healing, health, safety, and a long, productive, happy life. Because she's a role model for all those other little girls who never found it within themselves to report. So she is a hero to many. And your sentence defies deterrence of others, which is one of the factors I have to consider. But again, I'm doing this not for you, but for her. As to count one, you are sentenced to the Michigan Department of Corrections for 60 months to 180 months with credit for 448 days served. You will pay a crime victims assessment in the amount of $130 and waiving fines and costs. It is very unlikely you are able to pay that. And waiving attorney fees, you have a public defender, and you will pay a $68 state cost. You will be on the sex offender registry, and before you leave the Department of Corrections, you will be apprised of the requirements of that. And I don't know, but I am assuming, and I don't want to assume, that the AIDS STD testing was done. If it was not, it will be done. You will, while you are in the Michigan Department of Corrections, complete sex offender treatment. Cognitive behavioral. And any other treatment recommended as you go through this treatment. You have 42 days to appeal and to request appellate counsel. The monies that are owed will be due within 12 months of your release from the Michigan Department of Corrections. Council, please hand him his appellate rights.
Yes, thank you very much, Your Honor. I have handed it to him. He now has. Thank you.
Additionally, I don't see anything in restitution. Was anything being done?
No restitution, Your Honor.
Well, in restitution, he will be paying for a transcript of the plea and sentence, which will be given to the mother of the child and given then to the child's therapist when and if needed. That is the least he can do in restitution, especially since he didn't even say, "I'm sorry." Sir, do you acknowledge your appellate rights?
Yes.
Thank you. That is all for the record.
Thank you, Your Honor.
Yes, count two. We just didn't, we wrote it back here. It should be count two.
Thank you.
So I just want to go back on the record on the last case. We're changing it, because it's a bit confusing, although it's the way they do the PSIRs. It's really charged two that he pled to, count one was dismissed, so it really should accurately reflect on that.
That's more accurate, Your Honor. Thank you.
Okay, thank you.
Thank you.
One of these two, I'm waiting to see.
Hold on a second.
Who?
James, Charles James.
This is docket 25. 2774 FH, people of the state of Michigan versus Kamari McCroy, how do you spell? Counsel, your appearances for the record.
Good morning, Your Honor. Natalie Mason, on behalf of the people.
And please the court, David B. Carter Jr. on behalf of Mr. Stump, who is being brought in by the deputy.
Thank you. Did you have an opportunity to speak with him?
I did yesterday.
Thank you. Thank you, sir. I just called your case. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and opposed to perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Yes.
Is it anything that would interfere in your ability to understand the court or your attorney?
No, ma'am.
Is there medication that you're supposed to be on that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you had enough time to speak with Mr. Carter?
Yes, ma'am.
And this is the final pretrial. And so I don't know what you're going to do. I'm sure I'll hear about it in just a moment, but if I would have the prosecutor read the plea offer, if there was one, then we'll talk about what happens, because we need to keep your case moving, okay? All right, on behalf of the people, was there an offer? And if so, what was it?
Your Honor, the last offer that was made to Mr. McCroy Stump.
There is really no offer. I'll cut to the chase because the prosecutor is stepping in for a sick prosecutor. But this case, my client maintains his innocence. So any offer is really not going to be entertained by Mr. stump. He totally is innocent of this crime and we want a trial. I think it's a mistaken identity case.
Okay,
Uh,
so I made a note of that. So you would agree with that, sir, that you want to go to trial?
Yes, ma'am.
Okay, we're gonna get you to trial. How long has he been in custody?
And I wanted to bring that up. He's been in jail for 8 months
We're
now.
gonna, unless the people, why? I don't understand why. I would have entertained.
I'm the second attorney that came in on this.
Yeah,
And all I can say is that if we were to go to trial and lose, his guidelines are 0 to 10 months. He's working with Peckham. He's done he's
how old
had,
are you, sir?
19.
Counsel, can you approach? I appreciate it. We all. So let's spread the thing around. Well, okay. So, sir, do you still live on South Martin Luther King?
Say that again?
Do you still live on South Martin Luther King?
No, ma'am.
Do you have a current address?
he's homeless, but with that said, he's been working with Peckham. They've got him set up where he's going to, within 3 days, he's going to be meeting with Peckham. He'll go to the homeless shelter. He's already worked through 2 of his GED tests. They've worked with him. He's been proactive while in jail.
Where's your family, sir?
They're all out of town, Indiana and Georgia.
Okay. Can you go live with them?
Yes, ma'am.
I would have to verify that. I mean, I know my clients oftentimes want to be overly optimistic when they're in front of a judge, but I can't vouch for that without doing some due diligence. But he's, as I indicated, he's working with Peckham, and he's got a plan in place to get a job. They're going to help him with housing. They're going to do all those types of things.
Have you held a job?
Can you say that again?
Have you held a job?
Yes, ma'am.
Okay, what do you do?
I used to work at Hunter House.
Okay, so you can do any restaurant, you're willing to do that work, get a job?
Yes, ma'am.
All right. How much time do you need to figure this apparent mess out?
Well, Your Honor, this is currently set for trial on February 20th. I think
Is that enough time?
between Mr. Carter and I, Mr. Bucks, I believe we should be able to sort out whether or not this is going to continue to trial or we'll have a different resolution.
Great.
If-
February 11th at 11 o'clock. Is that enough time?
February 11th,
Yeah.
oh, that's on a Wednesday, okay.
Is that okay?
Yeah, Stokes doesn't do trials on Wednesdays.
Nope,
right?
none of us do.
All right, yes.
I'm going to call in a final pretrial. I'm going to continue this final pretrial. All right, sir, I'm going to give you a $5,000 PR bond. You'll report to pretrial services as directed. You shall not use, possess, purchase, or be in the presence of any illegal drugs, alcohol, or drug paraphernalia. You will show pretrial services any prescriptions, take any psychotropic meds as prescribed, follow your doctor's recommendations. You will PBT and/or drug test as requested by pretrial services, law enforcement, any court officer, or family member you live with, adult family member you may live with. You will not have under your control, in your possession, or in your presence, any weapon, gun, ammunition, or imitation of a weapon. You'll not be in the presence of anyone who has those items or any contraband. You'll not be in the presence of any known gang members. You'll not wear any gang colors, gang tattoos, or gang insignia. You'll maintain your residence, and any address change will be reported to pretrial services, the court, and your attorney within 24 hours. You will appear for all hearings and proceedings. The next court date is February 11th at 11 a.m. And you'll work with counsel to verify address, maintain housing, and obtain employment. I don't have any problem if he needs to live with family out of state. I don't think homeless shelters are the answer for a young man. So I don't have a problem. We can, as long as we comply with certain requirements and we work it out.
I agree, and I've discussed all that with him, but he really is invested in this plan that he's been working with Peckham and really.
And that's fine, but once he gets his GED and does whatever, I mean, let's look at how he's doing. If he's doing fine and there's gonna be a trial down the road or what have you, let's get some normalcy back. This is unconscionable. It's been 10 months in lockup on these charges. Not that these aren't serious, but no,
Look, we're entertaining a GPS tether.
no, thank you.
Thank you, Your Honor.
Furman or
Which one?
Furman?
Sorry. Which one was that?
Okay, we're ready to do Roy, Sally. and
Yeah.
Sally.
I didn't hear that second one again, I'm sorry.
Furman?
Firm,
The PD?
gotcha. Oh.
Docket 25-4217FH, People of the State of Michigan versus Royce Alley. Counsel, your appearance for the record.
Good morning, Your Honor. Natalie May from Brandon, back with the people.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Mr. Ali. I'm appearing in person. Mr. Ali is appearing by Zoom as his audio and video appear to be working. Your Honor, may I approach on a plea form?
You may.
Thank you.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And have you had enough time to speak with your attorney?
Yes, ma'am.
And I understand this is going to be a plea?
Yes, ma'am.
All right. If at any time you wish to speak to your attorney, let me know. We could put you in a closed Zoom room, okay?
Yes, ma'am.
And you are in agreement with proceeding like this on Zoom rather than standing next to your attorney, is that correct?
Yes.
Okay, if it's not correct, we can schedule it for a time and bring you over here. It's up to you.
Oh, yes, ma'am. I'm okay either way. Yes, ma'am.
Okay, making sure. So, are you a US citizen?
Yes, ma'am.
And the offense that you're pleading to, were you on probation, parole, or bond conditions before another judge? Do you understand the question? At the time of the offense, were you on probation, parole, or bond conditions, or counsel, do you know?
Your Honor, this was back in April 10th of 2023. So Mr. Ali, to the best of your recollections, were you still on a term of probation at that point? We don't think you were, right?
No, sir. Oh, no, sir. No, sir. I mean, no, ma'am. No, ma'am.
All right, thank you. And on behalf of the people, what is the plea agreement? And the court has signed it. You'll all receive copies in just a moment, but for the record.
Your Honor, the agreement in this files for the defendant to enter a guilty plea as to count 2. Upon successful plea and sentence, count 1, and individual notice will be dismissed. Further, there is a sentencing agreement to no further upfront jail at the time of sentencing.
Is that full, fair, accurate, and complete counsel?
Yes, Your Honor. Thank you.
On behalf of defendant, did you, sir, hear the plea agreement?
Yes, ma'am.
And is it full, fair, accurate, and complete?
Yes, ma'am.
Okay. And counsel, are you waiving reading counts 1 and habitual offender fourth offense notice in its entirety?
Yes, Your Honor.
As to count 2.
Thank you, Your Honor. The people of the state of Michigan versus Royce Eric Delanier Ali, case number 25-4217FH. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs this court that on or about April 10th of 2023 at South Cedar and Edgewood Boulevard in the city of Lansing, Ingham County, the defendant did in count 2 controlled substances, possession of cocaine, heroin, or another narcotic, did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine and or fentanyl, contrary to MCL 333.7403285. This being a felony punishable by up to 4 years and or $25,000 in fines. Court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at arrest. This being done against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, ma'am.
So you understand count 2, possession or controlled substance known as cocaine and or fentanyl, less than 25 grams is a felony punishable by 4 years and or $25,000, and there'll be forfeiture of any contraband, including those substances.
Yes.
All right. And did you sign an advice of rights form, sir?
Yes.
Do we have that? I just have the agreement.
Your Honor, we reviewed the form together. He's appearing remotely, but I did show him the form. And if Your Honor could read him the form, or I could sign the form with his permission.
Sir, did you have an opportunity to go over the rights with your attorney?
Yes, ma'am, we did.
And would you like me to go over them with you?
If If you have to, Your Honor, but me and my attorney went over it.
Well, if you're satisfied that you understand them, I'm happy to not do that, but I certainly can go over that with you on the record here.
Yes, ma'am.
All right, so sir, you have a right to a bench trial or a trial by jury with the presumption of innocence. The people have to prove you guilty beyond reasonable doubt, that's their burden solely. And if they're unable to prove that, then any count that could not meet that burden would have to be dismissed. You can cross-examine, and you have the right to cross-examine any witnesses and evidence brought against you. You also have the right to remain silent and to not do anything at all, but you also have the right to choose to provide a defense. If you choose to provide a defense, the people can cross-examine any witnesses and evidence you present, and as to any witnesses, the court would order those witnesses to be present. You have the absolute right to remain silent. Your silence cannot be used against you. However, you also have the absolute right to choose to testify. If you chose to testify, then the people could cross-examine you. Additionally, as to your appeal, if you choose to appeal, if you have a trial, bench trial or jury trial, and you are unhappy with anything, the Court of Appeals must take a look at your unhappiness. But now choosing to plead, it becomes the Court of Appeals decision as to whether or not they think your issues are important, and they will only take up your case if they believe that your issues are important. Do you understand all of those rights?
Yes, yes, ma'am.
All right, do you have any questions for your attorney or for me in regard to your rights?
No, ma'am.
Thank you. And sir, as to count 2, possession of a controlled substance known as cocaine and or fentanyl, less than 25 grams, how do you plead?
Guilty.
And sir, if someone forced, threatened, coerced you, promised you something, not the plea agreement, but anything else, and that's why you're pleading, you need to tell me that now, because if you come back here and say, Judge, I should not have pled, I do not have to accept that. Do you understand?
Okay, yes.
Okay, have you pled of your own free will?
Can you say that again, Your Honor? I can understand you.
Okay, have you pled guilty of your own free will?
Oh, yes.
And you did that after you consulted with your attorney?
Yes, ma'am.
And you've been satisfied with the representation of your attorney, is that correct?
Yes, ma'am.
There's a recommendation for no upfront jail at the time of sentencing. If I give you upfront jail at the time of sentencing, I would allow you to withdraw your plea. Do you understand that?
Okay.
However, if you violate the law or bond conditions between now and sentencing, I do not have to honor that, and I could sentence you to jail or prison and not allow you to withdraw your plea. Do you understand that as well?
Yes, ma'am. Yes, ma'am, I do.
Other than the plea agreement, has anyone told you what I will do at sentencing?
No, ma'am. No, ma'am.
And they couldn't have, because I don't know much about your case. I will make up my mind about sentencing at the time of sentencing. Do you understand that?
Yes, ma'am.
Did this offense occur on or about April 10th, 2023?
Yes, ma'am.
In the city of Lansing County, Bingham, state of Michigan?
Yes, ma'am.
At a specific location known as South Cedar and Edgewood, you came in contact with law enforcement?
Yes, ma'am.
And how is it they came in contact with you?
Approaching a vehicle, pulling over a vehicle, we was pulled over.
I didn't understand that. They approached your vehicle?
Yes, it was my uncle's vehicle. I was the passenger. Yes, ma'am.
Okay, why did they stop the vehicle?
Probably that comes to a complete stop, or just a regular probable cause, I believe.
Counsel, do you have any idea?
Yeah, Your Honor, it's my understanding that they were under investigation for a possible civil infraction moving violation, and also, from what I understand, the registration was expired.
Okay, and so law enforcement stopped you, and how is it they came to find the, controlled substance?
I told them that I had illegal substance on me when asked.
Okay, and then, where was the substance found?
I pulled it from my pocket.
And you had placed it there?
Yes, ma'am. Yes, I had it in my pocket.
Okay, so you placed it in your pocket, and you knew it was a controlled substance known as cocaine and or fentanyl?
Yes, ma'am.
And you didn't have any license or special authority or permission to have that controlled substance, is that correct?
Yes, ma'am.
All right, and was it less than 25 grams?
Yes, 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 yes.
Okay, okay, we're almost done.
No
And
problem.
do you remember this of your own memory, or were you high or intoxicated at the time?
No, ma'am, I wasn't high. I didn't have the chance to use the substance because we was pulled
Okay,
over and
okay, thank you. All right, and I understand that there was a test done of this and it was the controlled substance, is that correct?
Yes, Your Honor, there was a lab report that was submitted and completed that did confirm the presence of cocaine. Thank you.
All right, thank you. On behalf of the people, any additional questions?
No, Your Honor.
On behalf of the defendant, any additional questions?
Nothing further, Your Honor. Thank you.
Our counsel where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
None, Your Honor.
Does court comply with the court rule?
Yes, Your Honor.
Court has, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 1 and the habitual offender for the defense notice are hereby dismissed. Count 2 will enter. Any outstanding warrants, if any, are hereby recalled and dismissed. And as to any contraband, and specifically the controlled substance, that is all forfeited. Do we have a sentencing date?
March 11th at 9:30.
Does that meet with your schedule, counsel?
Yes, Your Honor.
All right, sir, you need to make an appointment with probation. That number, I'm sure your attorney can give it to you, but I'm gonna give it to you right now. That number is 517-483-6100. You'll need to call probation and keep an appointment with them to do a detailed pre-sentence investigation report that we need for sentencing. If you fail to do that, a bench warrant will immediately issue and you will sit in jail until they come and see you. Do you understand?
yes, ma'am. So I don't get in contact with Mr. Andy Geyer anymore.
No, pretrial services, you still need to contact pretrial services, but now you also need to contact probation at that number, the 483-6100, and make an appointment with them. All right, if you
Okay.
have trouble doing that, please contact your attorney and he'll help you, okay?
Yes, ma'am.
And then we're gonna see you March 11th at 9:30, okay?
Yes, ma'am. Thank you, Your Honor.
Bond conditions, thank you. Bond conditions are continued. Thank you.
Thank you, Your Honor.
Okay.
Yeah, man, I had to. Hold on, wait. What?
Yeah.
This is Zoom.
Next.
Suppressed. Yeah.
All right, we are going into a suppressed matter, so anybody not involved with the next matter, please step out. We'll call you back in just a few minutes.
Start video.
Correct, ma'am?
Yes, Your Honor.
And do you still live on Edgewood?
No, I don't.
Do we have the new, Brian, do we have the new address for there?
7317 Yellowwood.
That is a mailing address. Can I give you a
I need to where you can be found if you're sleeping. Where is that?
929 West Kavanaugh Road, apartment 10, Lansing, Michigan, 48910.
Okay, so we have both addresses. Thank you. And are you gainfully employed?
I start tomorrow at Big B.
Oh, one of my favorite places, aside from Starbucks, yes, good for you.
Thank
All
you.
right, and are you a US citizen?
Yes, I am.
And did you graduate high school?
I did. I started college yesterday, actually. It was my first day.
Oh, great, where are you going?
LCC.
Good, good school, okay. And I understand there's going to be a plea today. Were you on probation, parole, or bond conditions during the event?
Yes, Your Honor. I'm on probation right now.
In front of me or someone else?
In front of you.
Okay, so, I don't know if they are going to violate you on this, but I'm gonna make a note that we're not gonna violate you on this.
Thank you.
Just spoke to probation agent this morning.
Okay. It's really not their decision, it's mine, so I'm just making the record. Okay, so I'm just gonna make a note, that we won't violate.
Thank you. I believe I actually already did a violation and I was supposed to do 2 weeks. I did almost 3 months or two months in county.
Okay, probably gave you credit for that, I have no recollection of that, but nonetheless, I just need you to know that if, because you're pleading to something, it could be a violation if you're on probation, parole, or bond, so, if it's been taken care of, great, if it hasn't been, we're not gonna do anything further since it's in front of me.
Thank
But
you
if
very
it
much.
wasn't in front of another judge, they could, so, but you
Okay.
don't have anything else pending, is that right?
Well, so when I actually went to jail for that violation, I have not been sentenced on it yet because I didn't take a plea for this yet, and I'm
Okay.
currently still on GPS tethered,
Okay, and how old are you?
27.
Okay. And is she? I mean, 7411 eligible?
Believe so, Your Honor.
Part of the agreement, Your Honor, is if she's eligible, there's no question, 7411.
Then we need to be in a closed courtroom. So I'm gonna grant it now,
Yes, Your Honor.
and then we can always take it away, but it is silly to grant it later once it's open.
Yes, Your Honor.
Sure.
We'll move to it. No, maybe not 30 minutes.
My screen still says Brian on it. It's got my name highlighted corner. Try it. Turn on the video.
This is docket 22-885 FC, People of the State of Michigan versus Michael Willie Hutchins. Counsel, your appearance for the record.
Angela Delver on behalf of the people.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Michael Hutchins, who appears today via Polycom from the Forensic Center.
All right, thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yeah.
Thank you. Put your hand down. Counsel, what are we doing here?
Judge, this is kind of an update. I'll try to take it. Ms. Del Vero can jump in at any point. As the court knows, there's a long ongoing history with regards to forensic issues for Mr. Hutchins. We recently received an updated report. I had requested a further adjournment so that I could get an independent that was performed by Dr. Quinn, Thomas Quinn. It does find Mr. Hutchins competent, despite my lay opinions to the contrary. I guess I'll put it that way. So that is the status. Nonetheless, we are still waiting on Dr. Quinn to perform an independent criminal responsibility. So at this point, I think the plan is to ask for another 30 days. Mr. Hutchins remains at the hospital under a maintenance order. So I would ask that the court just give us a new date and we can get done for the purposes of today, I guess.
All right.
The court has previously entered an order finding Mr. Hutchins competent, so we're not under a 15-month timeline. This was just a secondary opinion that the defense wanted to get as it relates to competency, so the court doesn't have to worry about that.
That's
Okay.
accurate.
So what about February 18th at 11:30? Is that enough time?
That works. I think so. I mean, I can let I think we'll take it now, and then if something changes, I can certainly update the court.
I have a sentencing at 11 that morning in front of you, so that's fine with me.
Great, so
You said at 11:30?
11:30, so what, it will only take a few minutes, so, and if you need to move it a week forward or backward, just get on my docket and just stipulate to it, it's not a problem.
Understood.
All right, so we're gonna get to you, sir, as quickly as we can, we're waiting on that final report, okay?
All right.
All right, do you have any questions?
No.
Okay, good luck to you, sir, thank you.
Thank you, Your Honor.
All right.
Please just,
Next, we're gonna do suppress one next. Yes.
Yes.
Can I call Mr. Zillmer?
Yes.
Thank you.
We'll do it.
Your Honor, may Mr. Palmer and I approach so we can go to the next case?
The right one.
No, but we're about to be.
Right here.
Is it good? All right, which file is this? Is this Bruce?
Hill.
Hill.
Yeah. Oh, no, it's
Okay,
right. It's me this time.
okay, very good. Are we unmuted?
Yes.
Are we muted?
We're unmuted. We should be good to go.
All right, this is Mr. Hill?
Correct.
Okay, this is docket 24308 FC, People of State of Michigan versus Denzel, or Brandon Denzel Hill. Counsel, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Your Honor, Jeffrey Kaplan, P 74943, on behalf of the defendant who stands to my right, Mr. Silverthorne is not able to be here today.
Thank you. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Okay, put your hand down, sir. You had a jury trial and the jury found you guilty of count 5, aggravated domestic violence punishable by 1 year. Do you recall that?
Yes, ma'am.
All right. Counsel, this is a misdemeanor. Do we need to go through all of this?
No, Your Honor.
I didn't even think that this identity order, the report to be done.
Yeah, is there a victim here who wishes to address the court?
No, Your Honor.
And I mean, there's a 365-day max on this. He's done 596 aside from costs. What are we doing here?
That is it, Your Honor. We're just statutorily required to have the other hearing.
Yeah, so sir, you get 365 days of credit for 596. And you will pay a crime victim's assessment amount of $75 and a $50 state cost. That's it. So it's $125. How much time do you need to pay?
Oh, just give me a month if you can.
Okay, so, great. This money will be due February 16th. Okay, the 14th is Valentine's Day. It's Saturday. So I want you to think of me on Valentine's Day. If you haven't paid that, you better pay it Monday.
I got you.
Okay?
Yes, ma'am. Your Honor.
All right. You have 42 days to appeal to request appellate counsel. Anything further for the record?
Not in this file, Your Honor. However, I believe the defense is going to be taken into custody on a felony warrant that was issued yesterday for bribery. It involves what he admitted to during his testimony in this case.
All right.
Seriously?
Yep.
You decided to leave that now. What class?
What?
Seen any research, I don't know. I'm sure your attorney will come down and talk to you.
Thank you, Your Honor.
Yeah.
Are you next?
I don't know. Sure, my guy's in custody though.
And Amory or Freisen?
No.
No, I have Williams, Ronnie Williams, and well, I have Freisen too. He's in the hallway. He's not pleaded.
No, we just are gonna get a jury trial date, and I'm gonna work with Barb.
Is he the one you want me to talk to?
No,
But this is the
No,
front.
that's Williams.
This is the
Is he
front.
coming out?
Freisen's the final though, right?
I believe so.
So we need to do that on the record. If you want to go get Freisen right now, do it on the record. We can do something. We do have 2 set-asides as well. Probably 11 or 11:30.
Y'all having fun?
Oh, yeah. Right, I just did an amended speed. Is there a way you can push it to me? Because I don't have to run
Yep.
upstairs.
Just email it to him. Or you can email it to me, whatever.
counsel.
For what it's worth, somehow I didn't realize this was a final today for Mr. Friesen. He's got 2 cases and at least one of them.
One's in bench warrant and the other one's criminal pretrial conference. Let's just see what we got here.
Okay.
This is docket 24-394 FAH and 25-6095 FH, People of the State of Michigan versus Anthony Bernard Friesen.
Good morning, Nicole, please go on behalf of the people.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Anthony Friesen Jr., just to clarify, this is junior. I just point that out, Your Honor, because I think seniors also has pending cases on your docket. So I want to make sure we're talking specifically about junior. I don't represent senior.
Okay, well, the one at the 24-394, that is, there's a bench warrant and that is in regard to a felony information that has assault with intent to create bodily harm less than murder or by strangulation and domestic violence with a second domestic violence and count 3 interfering with electronic communications. And is that your file?
Yeah, yes, the
Okay.
2 for Mr. Friesen Jr. are my files.
Okay. And
I'm not clear though why he's in bench warrant status.
well, let me see. It says we should get your copy of this. This was from October 16th is when the court signed it. It says on October 14th, 2025, defendant allegedly violated the terms and conditions of bond release. To it, defendant did or attempted to have direct and or indirect contact with the victim, Sierra Thomas. And through these actions, the victim was in fear of defendant obtaining her location. It is further alleged that defendant told police officers that he had been having contact with the victim since the Public Act 53 was issued and had been living with the victim for 2 years. Additionally, defendant was in possession of 36 pre-rolled marijuana cigarettes. Would you like a moment to talk with him?
Well, Judge, I think some of that is the basis of the new case.
Okay. Obviously, I don't know. Let me see, the new case is aggravated stalking.
Correct.
And it does have her, so we just hold everything in advance.
Yeah, I would ask that it be held in abeyance, Judge, because I don't know how we defend that charge without kind of going into the facts of the new stalking case.
Okay, so tell me, so we'll hold that in abeyance and continue that. What is there's a final pretrial. What are we doing with this?
Well, I think that here's the deal. We originally had or were close to a plea agreement worked out in the original case. Then he was charged in the new stalking case. We ran a preliminary examination in that. I realized that Ms. Matusko was not present at the examination. I will say from my standpoint, I'm not sure I've ever seen a complaining witness lie so much. It's not before the court today, but it was absolutely absurd. We are waiting on a preliminary examination transcript. I also do want to raise, I'm concerned about a potential bond violation coming, and I'm just going to put this on the record now and to try to cut it off. The complaining witness appeared today, even though I don't believe she was subpoenaed. She's free to come to the court. She has all morning been following Mr. Friesen around. He tried to go out to his car to grab something. She followed him to his car. It appears to me that she is trying to trigger a bond violation so as to get Mr. Friesen locked up. Mr. Friesen, to his credit, has been going out of his way to avoid her today. As soon as he realized what was happening, he came straight back into the court, knowing that there was cameras here. He sat on the bench directly outside the hallway, so there could be no question. I've been doing my best to keep an eye on him. At this point, I guess the point is, I don't think we have a plea. We did have a plea originally, but there was a second case now charged, which kind of blows things up. I guess we are sort of steamrolling towards trial.
So let me do this. Do you waive further arraignment?
I wait further arraignment.
We are going to hold everything in abeyance. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide with the truth, whole truth, and nothing but the truth, and the penalty of perjury?
Yes, ma'am.
Okay. This case warrants further investigation and discussion with the prosecutor's office. I need you to continue to stay clear of the victim, and if she does in fact follow you, I suppose what you need to do is get a personal protection order against her. would certainly be warranted. I don't know what the family division or probate division will do with that, but that is a concern. So document it, call 911, call your attorney, and turn over that information to the prosecutor's office because they would want to know about that. So I would ask the two of you to please have a seat. And Ms. Thomas, are you here?
She was, I think I suspect she left.
Do you know how to identify her?
I do. I saw her sitting in the back of the
Could
courtroom.
you look at her and see if she's, sir, you stay here. Could you please see if she's in the hallway? I'd like to have a chat with her.
I will.
Thank you. Do we need you accompanied by the officer? All right. Mr. Palmer, would you like the officer to accompany you?
Sure.
Great. Well, I just don't want her to flee.
I get it.
Yeah, man.
Well,
Sorry, I'll bet
It's a
it's
weird
later.
mistake.
I think it's just easier to have it than to try to reason that.
It doesn't fun for it.
Stop, it's cool. I get them all. Like
Brian?
Yeah.
Is the PPO office open during lunch?
No, they're closed from noon to 1.
She appears to not be present any longer, Your Honor. She's not in the hallway and the office will check that.
All right. I just asked Brian because he used to work at the PPO office. They're not open between 12 and 1, but sir, I don't know if we can get you the paperwork or whatever, but, or if you want to stick around, go downtown, have lunch and come back, but I would suggest you get a personal protection order.
You should be able to get the paperwork from the clerk's office downstairs too.
Would they still have it?
Yeah, they should
All
have.
right,
paperwork.
I mean, I don't know if they'd grant
And they
it,
don't.
I would if it was brought to me, but I don't have any jurisdiction over her, but the court downstairs can take jurisdiction of that. It's unconscionable if that's going on, we really need to document it. You might want to take your phone out and have a camera, take pictures, do whatever. We need to get you to trial, but if this is going on, it certainly sheds a whole new light on things, so I deal in evidence. So work with Mr. Palmer, he's very good at what he does, and he'll work with the prosecutor and maybe we can get resolution. Is that all right with you?
Yes, ma'am.
All right, so keep doing the right thing, stay away. I know these allegations that you were living with her and all of this have been swarming around here. It's in your best interest, no matter what, to stay away from her.
I'm trying, so that's all I can do is try.
Yes, well, but if she's coming in your space, you really gotta let them know and document what you can, all right? Is
Yes,
there
ma'am.
anything else for the record?
Nothing on behalf of people. Thank
No,
you.
Your Honor, thank you.
Thank you. Oh, wait, we need a new date. So, can I give you a new date? I'm gonna give you a date of March 18th.
What is that for, Judge?
Whatever it is you want to do, status conference, dismissal, final pretrial, I don't know.
I'll take the dismissal, but
Well, that's not my jurisdiction. That goes to all of you.
Your Honor, if we could set that for a status conference, since we're waiting on a transcript, that'll give us time to follow up with the district court.
Great, March 18th, at 11:45, won't take very long.
could I just have 1 second to talk to Ms. Matusko?
What are you doing back for?
Setting aside, or no, holding it in advance, just holding it in advance, we'll see. But I've already arraigned them and I don't.
Four total files left.
That's
There's 5 left.
Your Honor, well, never mind. Ms. Matusko and I would follow up with potentially off the record, I guess I'll put it that way.
Okay,
Thank
great.
You'll kill me. Can we do those set asides real quick?
Oh, I have to look them up in my thing.
We can make the copies real quick.
Yeah, if you make me copies, I can go. over this.
Absolutely.
Oh, no,
Do a quick benchmark.
that would be great because
Oh, okay.
you can make your copies, give you the.
Which one?
Michael Ainley. He has 2 files.
All right, this is docket 25-4868 FH and 25-4866 FH, people of the state of Michigan versus Michael Jamal Amory. Counsel, your appearances for the record.
Good afternoon, Nicole Machuska on behalf of people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Amory, who is not present today.
Counsel, I was just looking at the file, we have two files, and it looks like he was homeless and then he was going to be living with his mother, whether or not that happened or not, I don't know. Do you know if he ended up having housing or was remained homeless?
I do not know. I saw him at 55th District Court on January 5th when I was there on another matter. But I believe he has a warrant out of there too at the moment from a follow-up hearing.
All right, well, this was scheduled for 11:30. It is now, what, noon? And so the court is waiting half an hour, bench warrant bond forfeiture on both, and we will let you know when we pick them up because we will.
Okay, thank you.
Thank you.
Your Honor, do you have a second? Can I introduce you to our new intern?
Yeah, yeah.
Carrie.
As long as it's a second, that's all we have.
Oh.
Here's the first one.
I wouldn't call you.
I was next to Chair of Justice.
Nowadays, you go stronger.
Would Andre himself?
It's great teaching.
Yeah.
Oh, yes, I
Okay, that's fine.
Yes.
Yeah.
Here.
Okay.
That's got to be. Oh, good.
They might do
Unusual case.
All right, thanks, Judge.
Okay, what do we got?
Here you go. Set aside, it's right there. Yep, she's got that one. I'm getting her the second one right now.
And then after these, Your Honor, we are able to go forward on the suppress sentence. Mr. Foreman's not going to leave the courtroom.
Okay.
Are you sure about that? Deputy, if Mr. Foreman tries to leave the courtroom, please take him into custody.
I'll be in the back of the court.
Thank you. Thanks, Bill.
All right, this is docket 14-418 FH, people of the state of Michigan versus James Foster III. Counsel, your appearances.
Good afternoon, Nicole Machuska on behalf of people.
And good afternoon, Your Honor. Dustin Coons for James Foster. We're each appearing by Zoom. James, can you turn on your video?
Did you give him permission to do that?
Yeah, they all have permission to do it.
Okay.
And I don't know which one out there.
James Foster, he's right there.
I will ping.
I'm trying to turn the video on, but the host has asked to start my video. Start my video.
Okay.
Okay, here we are.
Sorry about that. All right. Minister Foster, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. And there's been an application to set aside convictions of fleeing and eluding third degree and police officer fleeing fourth degree. And the date of the convictions was August 6, 2014, and this application was filed on October 17th, 2025. On behalf of the people, have you received the requisite paperwork, reviewed it, and is there any objection?
Good, I have received the paperwork, I have reviewed it. The Attorney General's letter, it makes an inquiry as to whether or not if offenses were made while operating a commercial motor vehicle, or if injury or death was a result, because that would make Mr. Foster ineligible. I have had a chance to review the prior PSI briefly before going on the record. Neither of those two circumstances are a factor here, so I do believe he is eligible. So long as the court finds it's in the public interest, we have no objection.
Thank you. Mr. Coons, what would you like me to know?
First of all, thank you, Ms. Matusco, for looking into that. We were going to provide evidence on that fact, but thank you. Your Honor, what I would like you to know about James is I think he's the exact type of person the legislature had in mind when amending our expungement laws a little over 5 years ago. Um, he's the kind of person who, under the prior regime, would have been ineligible for an expungement for two reasons. One, no traffic offenses were allowed to be expunged before the Clean Slate Act. Two, he has multiple felonies. But as you know, the expungement laws are a little bit more liberal now. And again, I think it's for people like James that that we have liberalized these expungement laws. He's been an incredibly hard worker since 2014. These incidents that led to his convictions, this incident that led to his convictions it was a huge wake-up call for him around that time. He started dating his current wife, who is it three kids, James?
Yes.
Three kids that are not biologically James's, but in every other way, absolutely are. He's stepped in as stepdad and taken care of them, raised them. He's worked incredibly hard over the years, taking whatever jobs he could to provide for his family. More recently, it's been a bit steadier. He's been at the same employer for, I'm forgetting how long, but James can chime in here in just a
I'm
moment.
going on 4 years with the local 7 sheet metal union out of Lansing.
Yeah.
Great.
So, the court is required to look at two things. One, whether he's procedurally eligible, and I think, as Ms. Matusco stated, he is. And then two, whether his circumstances and behavior since the time of the offense warrant the set aside, and if it would be in the public interest to do so. And I'll let James speak a little bit more on what's been going on for the last 12 years or so in his life, but I think we've absolutely established that, and I am asking that both felonies be set aside. Thank you.
Thank you. Sir, what would you like me to know?
Your Honor, over the last decade, I met a woman, and this year, July 26th, I married her.
Met a woman.
Yeah, I met a woman over a decade ago, and she had 3 children, and the biological father, he hadn't been around, and I started raising the kids, and was trying to right some of my wrongs. At that time, I had made a bad choice, and I was going through the process of completing my sentencing, and I just all of a sudden the kids, they took a liking to me, and they asked me if I'd be their father, and so now I'm going through the adoption process, and my youngest is 15, and my second youngest is 17, and then my 16-year-old son, and so they're really excited to take my last name, and just trying to better myself, and lead by example, and make good choices, and so far it's been going really well. I'm getting ready this year to take my private pilot's license, and we just bought a house last year. With the incident, how this occurred, I was hanging out with some people that weren't making the best choices, and that night I ended up following suit, and it's haunted me ever since it's happened. And like I said, I feel terrible as some of the jobs that I've tried to inquire over the years. Professionally, I have a CDL A air brakes, And so that was a big hurdle to try to get over, having 2 felonies for fleeing and looting on my record. And I honestly, I don't feel like a criminal, and it hurts when I'm sitting in front of an owner and he looks at my record and says he can't hire me because of, my past. And it was it was a terrible choice, and I just as soon like to right my wrong.
Well, it certainly sounds, sir, like you deserve this, and you certainly earned it, and you will continue to earn it raising teenagers.
Absolutely.
So, congratulations on being the role model they need and stepping up to the plate to be their dad. That's just really huge and speaks very well of you. So I appreciate that.
Thank you, Your Honor.
So, sir, I am going to grant you your request. The court finds the Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assault of crime set aside under the statute during their lifetime. There are no criminal charges pending against the applicant, and the applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant has not previously had a felony conviction for the same offense set aside under the statute, and the time period required pursuant to the statute for the convictions listed in item 1 has passed for all convictions. The convictions listed in item 1 occurred within 24 hours and arose from the same transaction pursuant to the statutes. They will be considered as one transaction. An opportunity has been given to the state police, the attorney general, and prosecuting official to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of the application more than warrant and justify setting aside the convictions, and it is consistent with justice and public welfare. Therefore, the application is granted as to the convictions listed in item 1. And pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. And sir, if you were here, I would ask you to approach the bench and hand you the order. So I'm doing that like this. If you're ever in the courtroom or courthouse, feel free to come up and tell me how you're doing, and let's take a picture. My final work on this file and order for you is to take out your lovely family to a celebration dinner. Can you comply with that order?
Yes, thank you, Your Honor.
All right, now we're gonna get this to you, and counsel, if you don't, if this doesn't happen in the next month, let me know so I can make a phone call. It doesn't happen overnight, sir, but the next few days or few weeks it will happen, all right?
Okay, thank you.
All right, thank you. That is all for the record.
Thank you very much, Your Honor.
Thank you. This is docket 15-421 FH, People of the State of Michigan versus Dion Davis. Counsel, your appearance for the record.
Good afternoon, Oklahoma, to on behalf of the people.
And for the record, Your Honor, Kelly Collins, P73222 from Project Clean Slate, on behalf of the defendant, Dion Davis, who is also present on Zoom, Your Honor.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. On behalf of the people, are you in receipt of the necessary documentation and paperwork from the State Police Attorney General?
I am, Your Honor, I've reviewed everything. The people have no objection to this conviction being set aside.
Thank you. On behalf of your client, anything you want me to know?
Yes, Your Honor. So we do have that Michigan State Police report, and as the court can see, there are some convictions related to alcohol. And what my client tells me is that at the time of this case, back in 2015, he was attending MSU. Alcohol was a part of his life, and he can certainly state that all of his issues in the past are related to alcohol. And he tells me he feels very fortunate that these cases happened because they were very eye-opening to him. And he learned that he had a big issue with alcohol and he had to change his lifestyle, and he did just that. His last case was in 2018. He stopped drinking. He tells me it was really a blessing in disguise that he had to go through this. He's been sober since 2018. He ended up graduating from MSU with a bachelor's in economics. He's been consistently employed. He's been working with a logistic company. He's been in that industry for a number of years, but he continues to have barriers due to his criminal convictions with employment, with housing. He really just wants his criminal history to reflect his current lifestyle and continue the path forward that he's been working towards since his last case. So we believe his post-conviction circumstances and behavior warrant setting aside this conviction, that it would be consistent with the public welfare, and we would ask the court to grant his application.
Thank you. Sir, what would you like me to know?
Well, first and foremost, just want to say thank you guys for even having me and giving me an opportunity to, hopefully have a chance to set my record straight or get it clean and, new beginning. This has been a huge monkey on my back for the past decade, one that I definitely deserve to have on my back. And my lawyer kind of explained it very perfectly. I can explain it better there. But I did realize with all these mistakes that I made, the people that I harmed, more people I could have potentially harmed, and more, I was definitely harming myself throughout that whole time. And I realized alcohol was the common denominator for all of my problems that I had in my life, the legal issues, and even the non-legal ones. To be, frank, obvious with you, a lot of relationships were shattered during that time of those legal troubles as well. But I found a way to rebound when I, quit alcohol and turned my life around, staying sober here. Started a great new relationship. Did well at my job. Was able to get great promotions. Go back to my job. So the new company was giving me a chance because they see what I've made in my life since becoming sober. And now, like my lawyer said earlier, I just want my record to reflect how I'm currently living my life: clean, sober, happy, away from alcohol, and no longer being a menace to society or myself. So I just want to say thank you guys so much. And at the same time, I do thankful, like you said, that I went through those problems because it made me realize, how much alcohol was a problem. If I never had these legal problems, I probably would be drinking to this day or not getting survived or behind bars. So very thankful that I'm not thankful that, if I harm anybody, but I'm thankful that it helped me see the light and improve my life and, come up from rock bottom there. I just want the opportunity to have my record, reflect that as well. And I think that's it. But just thank you again.
Well, that's very well said. I always wish that every high school student and college student would hear when people like you speak, because it is a hard road to come back from, and there's nothing to be gained by using alcohol. I mean, it's legal, but too much is illegal. It causes problems, and you've lived the life that shows that it's really not worth it. So I appreciate your words and your realization. An application to set aside the following conviction was filed on October 13, 2025. Police officer assaulting, resisting, obstructing. And the date of conviction was 7/1/2015. The court finds Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assault of crime set aside under the statute during their lifetime. There are no criminal charges pending against the applicant, and the applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute. The time period required by the statute for the conviction listed in item 1 has passed, and an opportunity has been given to the state police attorney general and prosecuting official to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of the applicant our application warrant and justify setting aside the convictions, and it is consistent with justice and public welfare. Therefore, the application is granted as to the conviction listed in item 1, and pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence in the applicant to the case which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read and signed and dated in open court. Again, sir, you're not here. If you were here, I would hand this to you directly and shake your hand. So I'm doing that virtually. We're going to make sure you get a copy of this, and the last order of this court is to take your family out for a celebration that you have earned, because this is really huge, and I appreciate you complying with the law and recognizing everything that you did wrong and coming back from it, because we all make mistakes. It's what happens afterward, the lessons that you learn that's important, and you certainly are a comeback star. So thank you.
Thank you so much, Your Honor. I appreciate it.
That's all for the record.
Thank you. Mr. Davis, you can log off.
All right, thank you, guys. Have a great one.
We have either suppressed sentencing or an in custody plea.
Makes no difference to me.
Mr. Foreman's here, and we're gonna do Mr. Foreman's because he is here.
Mr. Palmer is also here on the.
plea agreement.
He was last because we like to see his face in the courtroom. So we leave him in here for as long as possible so he can gaze upon what is Rob Palmer.
Hey, Ryan.
That's me.
You're recording me. Okay.
I'm in a relatively good mood though, because I fled my guy this morning, so we're now on the track case next week.
Oh. With which prosecutor?
Sarah was there today. Yeah. But I worked the deal out with just, Sarah.
So while he talks to his client, will you come here on a totally separate matter and look at something on the computer that pertains to the problem?
Oh.
Yeah, I don't. Let me see. It's changed. I don't know. Yeah.
I have some.
Yeah.
Oh, okay.
And then.
As soon as I get that. I'll make sure. All right.
Okay, I'll mention.
Yeah. So I'm gonna.
They'll schedule it. So we don't know.
I don't know for that.
We go with it.
This was.
They were here this morning. I wrote Andy Burke.
Will you see what I printed?
It's not, work, it's not, so. What this is, it's count 3.
Yeah.
And count. They do this, this is a kind
Held
of.
up records on the plea on.
Right.
I don't know.
Right, you're not charged with this count.
Oh.
No, not that, sorry.
I
had a question about.
So that's why that's it.
I don't know if
Even though, if you look,
I don't have, this is the.
Sounds like you guys-
See, I don't have it.
So he's the one that was just.
So that's what.
Oh, yeah.
Yes.
Do you think he was only guilty on?
Oh, not only, no.
So.
He's on like, I mean, obviously.
So that's.
Oh, God.
Yeah, but I don't remember what it was.
We had 9.
Right.
This is the most recent one.
Thank you. Yeah.
It's really during the litigation. Yeah.
And that's why I was like, you just.
Yeah.
Going back that way.
Negotiations.
Somebody to tell me everybody's gonna be okay with it.
I will say it. Yeah, no, I think we got it, but it was like literally the same day.
Oh, maybe.
Yeah. Oh,
yesterday, if you could review it, just let me know.
Yeah.
Sign off on it.
Is, people sign up?
Yes, she does sign up.
Great.
Ms. Matusco. He says I wrote 4. I put my perfect. Someone else that talking right here.
Oh.
I got real distracted.
Where was
I'm
it?
not gonna lie. I was like, damn.
I got purple.
Oh.
Where was it, Jen? Where was it? Oh, it was mine.
Person, right? My mom got PO, and she got no
Oh,
problem.
I
Like,
wonder what
she
it was.
can't help it. Why are you great? Are you left-handed?
So, do you want, we're gonna make, Brian's gonna make copies?
Yes, if I could get some copies and if we can make sure that gets entered in the pretrial and, you know, whoever needs to do whatever. Thank you, Your Honor.
I know, I had a Monday downstairs.
I bet.
There's a domestic, apparently domestic in the stairwell earlier too, that's why they went running out here.
Oh, I didn't even know
I
I
didn't
running out here. There's been
Yeah.
so much commotion here, and I don't know what.
Yeah, they come running out of here and I was like, what's going on? They're like, oh, there's a domestic in the stairwell.
One of ours?
I don't know, I didn't ask.
Geez. You gotta get a little bit of something, because we had a weirdo day today.
Didn't ask. I was talking to you like clear. They said they heard the guy, like, I know it's Aquilina. Oh, the guy's screaming, yeah. Oh, yeah. Why do you know it's hard?
Yeah.
Like, oh, yeah.
They're just, they should actually. Lawyers.
Oh, yeah.
Do that, hand it down, he's done.
Your Honor, may I approach?
Of course.
Are you ready for us? Should I bring you to the podium?
Yep.
All right, come on, Eric.
Get this sheet, and put my signature on there.
I'll get hold of, I think, Judge McCormick, maybe?
Ask her. Okay, do I have this file?
You do now. I don't know.
All right, this is docket 25-1714 People of the State of Michigan versus Ronnie Williams Jr. Counsel, your appearance for the record.
Good afternoon, everyone. Just wanted to have.
Good afternoon, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Ronnie Williams, the gentleman who's standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Sure.
Raise your hand down. Sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And have you had an opportunity to speak with Mr. Palmer?
I did.
And I understand there's going to be a plea,
Yes.
and you are ready to do that today?
Yes.
Thank you. On behalf of the people, well, let me ask you first, are you a US citizen?
Yes.
And were you on probation for all bond conditions at the time of whatever it is you're pleading to?
Yes.
Was it probation?
Yes.
Was it in front of me?
Yes.
All right. So did we already violate you or not?
Judge, I can address this. My understanding is that the court, well, so he's had some probation violations. Just to be clear, the two files are 23-571 FH and 23-687 FH. 687 is a CCW case. 571 is actually a misdemeanor ag DV case. There, for some reason, the PSI was combined and they did one PSI for both files. Back in February of this year, he was seen by the court. He admitted to some violations. The court at that time had levied a sentence wherein you were going to send him for inpatient treatment, followed by sober living. However, because of the case that's now before the court, he hasn't actually left the jail. He's just been sitting in the jail since that time. So he never actually went to the treatment. We did have a, I guess, unofficial off the record discussion this morning where Ms. Matusco and I advised you that that was the situation. There is a killabrew for no upfront jail in the case that he's about to plead into today. But I think, I don't want to put words in the court's mouth, but I think my understanding was that the court was either going to keep him on probation and continue to send him to treatment as part of those other files, or alternatively, and I'm not sure the court made the decision, but alternatively, just close those other files and sort of give Mr. Williams a fresh start here in terms of probation. My preference, just to keep it cleaner, would be to close those other files, but I guess to
Can
be
you give me
clear,
the two numbers again?
yes, it's 23571 FH and 23687 FH. As I say, my preference would be to close those other files and just give Mr. Williams a fresh start. He's been in custody almost a year now.
Okay.
I think it would be cleaner that way, but there's no agreement to that, to be clear, so I'm just.
Yeah, I think it may be best to set them all for the same sentencing date, and then we can address all three files at the sentencing hearing.
All right,
And then the
well-
court would have the file in front of them to do whatever needs to be done.
That makes sense.
So my inclination is to send him to treatment now. Once he pleads, he's eligible for treatment. Send him to treatment now. So he starts now, and then we'll see where he is at sentencing, depending on how long the residential treatment is. And then at the time of sentencing, I would close the other files, give him credit for all the time he served and what have you. Just close them successfully as long as there's nothing else, and then deal with this file solely.
I'm fine with that, Judge. If the court, I can say that Mr. Williams has desired treatment for the entire time I've known him. He just couldn't get there because of this file.
Right, so now that he's pleading, he can, and then we won't waste the time.
Right. I agree. I guess the court can obviously adjust the bond. To be clear, or to be fair, the agreement we made said no further upfront jail at the time of sentencing. Mr. Williams was aware that he may have to sit until that sentencing date, but obviously we don't have any objection. If the court's intention is to send him to treatment, we have no objection to that.
He's not gonna do further upfront jail, he's gonna do at the time of sentencing, but he's gonna do treatment, and whenever he gets out of that, he gets out of that, and then he can go home.
Right. All I'm saying is, I think he was understanding that he may have to sit in jail until the sentencing. If the court wants to accelerate that process, obviously we have no.
No, I'm accelerating it.
Good.
It doesn't make sense for you to go home, then be sent to treatment and this volley back and forth. It actually sets you backwards. So if you go, I don't know how long, I don't know if beds open or not, but they're usually open very quickly. They may very well have beds open today or tomorrow. I don't know, but they'll be open very quickly. And then you go to treatment. And then whenever you're done with treatment, you go home and you'll have to start reporting to probation and doing the right things. Doesn't mean jail's off the table. It just means the jail is reserved for any bad behavior, and hopefully there is none. Hopefully we can get you to a place where you are rehabilitated and you have the tools, if you have a setback, to use so that you don't land back in jail.
All right.
Is that all right with you?
Yes, sir. Judge, yeah, that's fine with me. I just also want to make the court aware the address and telephone number that are contained on the plea documents for Mr. Williams, because he's been in custody so long, he doesn't have his own address or phone number. Those belong to Mr. Williams' sister, Caitlin Williams, who's also present in the courtroom today. My understanding is that at whatever time he's done with jail and treatment, he will be residing with Caitlin at least until he can get on his own feet.
And that's fine. It's just that you'll have 24 hours every time you move, have a change in phone number, address, something happens to tell us what's going on so we can locate you, okay? Because, you know, when people abscond and I can't locate them, I certainly can locate them in the jail, and then, you know, we don't want to do that.
All right.
All right?
All right.
All right. Very good. So now that we've cleared all of that up, what is the plea agreement for the record?
Thank you, Your Honor. Today, the defendant will be pleading guilty to count 3, domestic violence, second offense, a 1-year misdemeanor, as well as adding count 4, attempted assault with intent to do great bodily harm, less than murder or by strangulation, a felony punishable by 5 years. There is an agreement for no additional upfront jail at the time of sentencing, so long as the defendant agrees to a term of probation. Upon successful plea and sentence to counts 3 and 4, the people move to dismiss counts 1 and 2.
Full, fair, accurate, and complete?
Yes, Your Honor.
Sir, full, fair, accurate, and complete?
Yes, Your Honor.
And counsel, you're waiving reading counts 1 and 2.
Yes, Your Honor.
As to the reading of felony information on counts 3 and 4.
Thank you, Your Honor. This is the people of the state of Michigan versus Ronnie J. Williams, docket 25-1714FH. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county, appears before the court and informs the court that on or about January 16th of 2025 at 3242 North Waverly in the city of Lansing, Ingham County, Michigan, the defendant did in count 3 commit the offense of domestic violence, second offense. The defendant did make an assault or battery upon Cerin, Cerrin, Elise Bradshaw, an individual with whom he or she had a child in common, and or an individual with which he or she had a dating relationship. This is a second offense notice, so take notice that the defendant was previously convicted of assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household by violating state law on or about January 4th, 2024, and therefore, upon a conviction, will be subjected to an enhanced sentence. If this offense resulted in damage to another individual's property or physical injury or death to another individual, restitution may apply. Domestic violence second offense is a misdemeanor punishable by 1 year and or $1,000. A consecutive sentence may be imposed under state law if the assault was committed in a place of confinement. The defendant did on or about January 16th of 2025 at 3242 North Waverly in the city of Lansing, Ingham County, Michigan, commit the offense of attempted assault with intent to do great bodily harm less than murder or by strangulation. The defendant did attempt to commit the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetration or was prevented in the execution thereof contrary to state law. That being assault with intent to do great bodily harm less than murder or by strangulation. The defendant did attempt to make an assault on Cerin, Elise Bradshaw with intent to do great bodily harm less than the crime of murder and or by strangulation or suffocation contrary to state law. This is a felony, 5 years, and the court shall order law enforcement to collect DNA identification samples.
And I don't think we made a record of the habitual offender third offense notice is being dismissed in its entirety. Is that correct?
That's correct, Your Honor.
Correct.
All right, so sir, you would agree with that?
Yes, sir.
All right, that just needs to be added onto the plea agreement form.
I believe the court has the original.
All right, thank you. And counsel, you waive reading then of the have third as well.
Yes, Your Honor.
Thank you. Sir, did you understand what was just read? So you understand count 3, domestic violence second offense is a misdemeanor punishable by 1 year and or $1,000, including restitution for any personal or property damage.
Yes.
If you disagree with any amount that's being requested, let counsel know and we'll set a restitution hearing in front of me, and I will determine the amount based on the evidence or lack thereof. The amount can go up, it also can go down. And then count 4, attempted assaulting, attempted assault with intent to do great bodily harm less than murder or by strangulation. That is a felony punishable by 5 years. Do you recall that?
Yes.
All right, and do you understand that? And so again, there's that restitution piece if there's any personal or property damage. All right. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes.
Did you understand what you read?
Yes.
If you had any questions, Mr. Palmer was able to answer those in regard to your rights.
Yes, sir.
Do you have any questions about your rights of this court?
No.
Sir, as to count 3, domestic violence second offense, how do you plead?
Guilty.
As to count 4, attempted assault with intent to do great bodily harm less than murder or by strangulation, how do you plead?
Guilty.
And sir, do you understand that by pleading, you're giving up certain rights and defenses you would have if you gone to trial, such as the presumption of innocence, holding people to their burden of proving the allegations beyond a reasonable doubt, not having to do anything at all to prove your innocence, choosing if you wanted to provide a defense, and if you wanted to do that, the court would order any witnesses you wanted to be present. You could cross-examine any witnesses and evidence that people brought. They could cross-examine any witnesses and evidence you brought. You could choose to remain silent or testify. If you chose to remain silent, your silence could not be used against you, but if you testified, the people could cross-examine you. Additionally, if you had a trial, the Court of Appeals would look at any of your unhappiness about that. However, by pleading, it becomes their choice of whether or not they look at whatever issues you raise to them. If they think your issues are important, they'll take them up, but they don't have to take your case up. Do you understand that?
Yes.
Now, has anyone told you what I will do at sentencing other than the discussion that we've had in the plea agreement?
Okay.
And that's because I'll make up my mind at the time of sentencing. Do you understand that?
Yes.
Now, if everything goes well, then if I don't follow the agreement, I would allow you to withdraw the plea. But if things don't do well, you could, for example, you violate bond conditions or the law, I don't have to follow the agreement and I don't have to allow you to withdraw the plea. Do you understand how that works?
Yes, sir.
All right. And you decided to plead after discussing the case with your attorney, is that correct?
Yes, sir.
And you pled of your own free will, meaning no one forced, threatened, or coerced you.
Yes, sir.
And you've been satisfied with the representation of Mr. Palmer on all matters?
Yes, sir.
Thank you. Sir, did these offenses occur on or about January 16, 2025?
Yes, sir.
In the city of Lansing County, Bingham State of Michigan?
Yes, sir.
At a specific location known as 3242 North Waverly in Lansing?
Yes.
And that's County of Bingham, State of Michigan?
Yes.
You were in contact with Saren, is that how your name?
Correct.
Correct, okay. She spells it different than other Corinnes I know, so I wouldn't have known that, thank you. It's Cerrin, Elise Bradshaw. Did you have a relationship with her?
Yes.
Was it a dating relationship?
Yes.
Do you have any children in common?
Yes.
And did you and she end up in an altercation?
Yes.
And did you end up touching her in an inappropriate way?
Yes, sir.
And was this touching in self-defense?
No.
Or how did you touch her? What happened?
We got into an argument and I pushed her and I wrapped my hands around her neck. I didn't choke her or cut off circulation.
Okay. But you weren't moving around and it wasn't done in self-defense, it was done in anger, is all of that correct?
Yes.
All right. And you were previously convicted of assaulting and battering your spouse or former spouse or someone you had a dating relationship with on or about January 4th, 2024, correct?
Yes.
And that's why there's this second offense notice, you understand that? So it goes from a 93-day to a year.
Yes.
All right. And sir, you just said that you did put your hands on her near her neck. And so you would agree that that is very severe, even though you didn't intend to strangulate her. It could have very well resulted in more damage because of that sensitive area of the body, correct? I don't know, counsel, I don't know the rest of the fact pattern, so if you need to ask additional questions.
I mean, I can try to clean up the attempt.
Yeah.
Mr. Williams, you placed your hands around Miss Bradshaw's neck, correct? Is that a yes?
Yes.
All right, and in doing so, as the judge already indicated, you were doing that in anger, correct?
Yes.
And I guess I'll say it this way, the intent at the time you did that was to strangle her, correct?
Yes.
All right, and due to your inability to sort of complete that action and or her squirming away, you were not actually able to choke her out, so to speak, is that right? All right, but that was your intention when it happened. All right, and you would agree that that was harmful or offensive?
Yes.
All right, I think that satisfies it now.
Your Honor, I believe that's
All
satisfies
right.
the factual basis, as long as the court has covered venue. I just didn't check it off.
I did.
I think you did, but just.
I did. They both occurred at 3242 North Waverly in the city of Lansing County, Bingham State, Michigan, correct?
Yes.
I think it's in their record 3 times now, but that's
Yep.
okay.
I just missed my check marks.
It's not a problem. And thank you. I don't get police reports, so I don't know I'm always asking questions sort of in the blind. So thank you for cleaning that up, Mr. Palmer.
You're welcome.
All right. Our council where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Has court complied with court rule?
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find that there are sufficient grounds as to counts 3 and count 4 on the amended information. Count 1 and 2 are hereby dismissed, along with any outstanding warrants, if any.
And the habitual offender notice.
Oh, and the habitual offender third offense notice is also dismissed. Do we have a sentencing date?
March 11th at 10 a.m.
Does that meet with your schedule?
That should work, Judge.
Sir, you'll need to make and keep an appointment with probation. We're gonna send you to, I probably need a bond sheet.
These are the same documents. This one she updated that one. Just as the-
All right. So, sir, you'll need to make and keep an appointment with probation. It's on that purple sheet, which you'll be given as 507-483-1600. I don't know, they might come and see you before you go to treatment, but I am going to put you on a bond. So as soon as you are accepted into a treatment program, this is for alcohol or substance, what?
Substance use, methamphetamine.
Okay. I appreciate your willingness to go to treatment. It's really important. All right, so I'm giving you a $10,000 PR bond when you're placed in residential treatment for meth. And you'll have to complete a program, residential program, and any aftercare. I don't know if the program will put you into some kind of halfway housing, or if you can go to your sister or wherever after. You just need to let us know what happens when you're released, but you'll comply with the program, not violate the rules. Some people get there and think, well, I don't have to abide by the rules, I'm free now. You're really not. You're going to be under supervision of them and comply with all the treatments, sign all necessary releases. We will never ask what you're talking about in treatment with your doctors or therapists. What we do though is probation will check and see that you are there, that you're attending, that you are compliant, you're participating, you're showing up on time. Some people just say, well, I'm not getting out of bed, that's not acceptable, okay? So I want to get you treated in the appropriate program that deals with meth rather than having you sit in jail doing nothing, okay?
All right.
All right.
And just to verify, Judge, if he is in treatment as at the time of sentencing, he may attend via Zoom?
Yes.
Thank you.
And sir, if you do want to be here in person, that's your right as well. So you just let us know wherever you are, that we'll figure out transport. But otherwise we can do it on Zoom. How old are your children?
I have a 7-year-old that turns 8 on March 15th, and I have a 16-month-year-old.
Wow, okay, so there's the no contact order with Ms. Bradshaw. So are you two, were you living together, married, what?
We were just staying together.
Okay, so are there family court orders?
I don't believe so.
Well, I had a meeting while I was incarcerated,
Okay.
but they didn't let me go to the meeting because I was incarcerated.
So is that, was that for parenting time, child support, all of that? Okay, so,
Yes. yes. Am I able?
All right, you will report to pretrial services. You have to let them know where you are, or maybe your attorney will, but if you're released prior to sentencing, which I doubt, but you'd still continue to report to pretrial services. You shall not use, possess, consume, purchase, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. You'll show pretrial services or probation, or I should say, and any prescriptions for medication from a licensed medical physician within 24 hours, and take any psychotropic meds as prescribed if any, and follow your doctor's recommendations. You will PBT and or drug test as requested by pretrial services, law enforcement, any court officer, probation, residential treatment program. And you will not adulterate any test. You will not have in your possession, under your control, in your presence, any weapon or gun, ammunition, imitation of a weapon. You'll not be in the presence of anyone who has any contraband whatsoever. You'll not wear any gang insignia, gang colors, or gang tattoos, and you'll not be in the presence of any known gang members. You will maintain your residence, and any address change will be reported to pretrial services, probation as it may be. I just don't know the status of where you'll be when you're released. And you'll complete all aftercare of the residential treatment program. You will report to probation. I'm gonna say within 48 hours of release from residential treatment. Okay, is there anything else I need to order?
No, you're
I don't believe so. Judge.
Okay, sure, so if there is, let me know. I got it all here, hopefully it's legible.
Understood.
Anything else, sir? You'll need to cooperate with probation for that pre-sentence investigation report. They'll probably come and find you at residential treatment unless they see you before you leave, but hopefully there's a guide available.
Thank you. Thank you, Judge.
All for the record.
That's what you're-
Thank you. So once there's been,
Yeah, because I know if you don't, I think another courtroom, they were releasing them, not transport
oh,
them.
hell no.
Transport them.
They go from jail to treatment, or they don't leave. Otherwise, they don't show, they hide, they die. So I'm not, I don't know what. That's Are we, is our volume on or off? We're on still.
I don't know.
So, I also paused the recording. You gotta pause it at the end.
Okay.
Can't leave it hours and hours. It also boots us out. This is docket 25-6217 CZ, in-ray transfer of structured settlement proceeds to Peachtree Settlement Funding LLC. Counsel, your appearance for the record.
Good afternoon, Your Honor. For the record, Joel Brand, P 51261, on behalf of petitioner, Peachtree Settlement Funding LLC.
Thank you. And
Your Honor, it's my understanding that Mr. McCollum should be physically present in the courtroom.
he's not here. We're going to check the hall.
Said McCollum? Yes.
That's a negative.
He's not here, counsel.
Your Honor, if we could pass this matter, let me reach out to him. I received a message that he was in the courthouse about 45 minutes ago.
Okay, maybe, yeah, double check and make sure he's in the right courthouse. I don't know. All right.
I would do so. Thank you, Your Honor.
Thank you. So just call them and see if they're coming. Maybe Stairs, they should know to call. They probably worked it out and just didn't have the courtesy to call us. All right, this is docket 24-540 CD. Catherine Oliveira versus Maynard, Casterian, PC, Edward Williams, Christine Lacha, and Joseph Zuziak. And this is a consolidated case, so it looks like there's also Kiera Berry versus Maynard, Casterian, PC, Edward Williams, Christine Lacha, and Joseph Zuziak. And then a third case, Aurora McKissick versus Maynard, Casterian, PC, Edward Williams, Christine Lacha, and Joseph Zuziak. And Gina Vermeersch, plaintiff, versus Maynard, Casterian, Edward Williams, Christine Lanshaw and Joseph Zuziak. And pending before this court is defendants Maynard Casterian, Edward Williams, and Christine Lanshaw's response to plaintiff's objection to defendant's proposed order. There was notice of presentment of order for entry under the 7-day rule. That was filed November 21st, 2025 at 2:07 p.m. No one has appeared, or has anybody appeared now in regard to this matter? There are some new people who've been on. Is anyone here on the Maynard Casterian file? Does not look like it. All right. So based on what I'm seeing here, there was an order under the 7-day. There were objections. No one has appeared for the objections. The court is finding that the objections are abandoned, and the court is going to sign the 7-day order. And then if someone objects to that, show up for a hearing. And they can also let me know why they didn't show up today. Court has signed the order regarding defendant Maynard Casterian PC's motion to compel supplemental discovery responses. There is no one here to object, and there's no reason for me to hold this 7-day order in abeyance any longer. Parties will receive copies through court. That is all for the record.
Next, let's do 5 minutes on it. You should all be If everybody, is everybody here for the cemetery matter and the memorial gardens?
This is AAG Smith. I am seeing two of the parties. I don't know that I see anyone here for Seville Township or for oh, there's Miss McAllister.
I'm here. I'm sorry if I'm late to the party.
No, you're not. Are you, and we're just a little early, one of the cases, they're looking for their client and we handled the rest, so we're just a little early. If everybody's ready, we can proceed.
We're ready, Your Honor.
We're ready, Your Honor.
Let me grab the file.
So we're putting two files because they had a binder. So there's the motion to transfer and then there's motions to intervene.
Your Honor, this is Mike Pomier on behalf of Seville Township.
Okay, let me just call the case and then we'll do all of this. All right, this is docket 07-1318.
Let me get out of this. No,
I'm sorry. This is docket 07-1318 CR. Counsel, your appearances for the record.
Janelle Orange for Albion Township. Good afternoon, Your Honor.
Jacob Whitty, also on behalf of Albion Township.
Lori McAllister on behalf of the conservator.
Michael Homer on behalf of Seville Township.
Assistant Attorney General Bridget Smith on behalf of Cemetery Commissioner Linda Clegg.
Okay. So any more of you I should look for? Looks like you're all here. So let's deal with the, there's a motion to intervene first, correct?
Yeah, there's two.
Correct, Your Honor.
Okay, so there's one from each township, correct?
Correct.
All right, so who would like to address the court first? Well, let me just ask this. Is there any objection on the intervention?
We've stated we leave it to the court's discretion, Your Honor.
Okay, well, granted for both, it makes some sense that they're in, and so everything can be worked out. If you would like to make a further record for appeal purposes, we may, but I think you've all adequately outlined everything in your motions. And if anybody else wants to be heard on it, let me know.
No, that sounds great, Your Honor. Thank you.
All right, great. Well, that was easy. So now let's get to the, or do we need, since you're just getting into the case, I suspect you know a whole lot more than just getting into the case, but now we have the petition to transfer the gardens to the township, correct?
Correct, Your Honor.
Okay, so why don't we start with the petition and then we'll see the responses.
Thank you, Your Honor. Your Honor, on behalf of the conservator, we have filed motions or petitions to transfer the two cemeteries to the townships where they are located. With respect to Albion Memory Gardens, we have petitioned to transfer that to the Albion Township. And with respect to Chapel Gardens Cemetery to Seville Township. Looking back, Your Honor, if you had told me 15 years ago when I first started working on these matters that I would still be working on them on the brink of my retirement, I would not have believed you. But here we are nonetheless. These two cemeteries, Your Honor, were basically taken over, purchased by a gentleman named Clayton Smart and his company, Indian Nation. And he totally took all of the funds that were supposed to be in trust, and they are to take care of the cemeteries over time. That is why the cemetery commissioner originally filed for conservatorship of both of these cemeteries. Since 2009, there has been a conservator appointed, always with the approval of the court. to operate these cemeteries. Eventually, my client, at the time Midwest Memorial Group, was appointed as the conservator. And although there have been several purchases along the line of Midwest Memorial Group, they have continued to serve as a conservator for these two cemeteries. They purchased the other 26 cemeteries that were owned by Clayton Smart and Indian Nation. At this time, the cemeteries are in the black. Albion Township currently has approximately 93,000 in its perpetual care fund. And the Chapel Garden Cemetery has approximately 108,000 in its perpetual care fund. My client, the conservator, has given notice to the state that it is no longer willing to serve as the conservator after January 19th, which is when the current order of conservatorship expires. Usually Ms. Smith and I would be coming in and saying, we need a petition in order to extend the conservatorship. And I think ultimately the conservatorship does need to be extended, but there also needs to be a conservatorship appointed, or the cemeteries have to be transferred. In all of the time that my client has served as a conservator, there has not been any interest on anyone's part in purchasing these two cemeteries. They truly are orphan cemeteries that need someone to take care of them. In light of that, we filed petitions under the Cemetery Regulation Act, which is MCL 456.181, and asked the court to exercise the power that and approve what the Cemetery Act authorizes the conservator to do, which is to transfer or convey the cemetery and any and all of its assets to a municipal corporation. And a township is included within the definition of a municipal corporation within the meaning of the act. We understand that neither the townships are very excited about this proposition. Unfortunately, neither is the state, and it doesn't have resources to run these cemeteries. And so without someone taking responsibility, these orphan cemeteries are just going to languish without someone maintaining them on a regular basis. We petitioned to have the cemeteries that are, the townships that are where these cemeteries are located to be the townships that where they would be transferred. I don't really see any legal basis that is brought forth by the township as to a challenge as to the authority of the court to make these transfers, or the authority of the conservator to bring this forth for the court. Now, we agree it says that the conservator may transfer or convey the cemetery, but that's what we're here to do, is we're asking the court to transfer or convey them because they have to go somewhere and they can't just stay out there in the Ethernet or wherever without someone to care for them. The biggest objection that has been raised by the two townships is, well, we don't know enough. We want to take financial due diligence. We want to do the things that you would do if this was a sale. Get in there, see the financial statements, find out how many graves there are, etc. If there's some information that you reasonably want, we are willing to provide it. We have already provided the information that has been requested of us. The in-house counsel at my client attempted to start a dialogue as as did Ms. Smith on behalf of the Attorney General's office. And it didn't get anywhere. And there's various reasons given by counsel for that. And I don't think any of us are here to cast dispersions. The bottom line is we are where we are, and we are very close to the deadline. And so we need to move forward with the transfer. This is not a normal transaction where they're going to go and say, oh, well, geez, we think the price should be something different. This is not a sale transaction. It is not something where if they don't like something in due diligence, then they can say, well, we're not going to take that part of the cemetery. This is a transfer pursuant to the Cemetery Regulation Act, which has no provision in it for the township to do the kind of due diligence that they're complaining that they haven't had. We respectfully submit, Your Honor, that these cemeteries need a home after all of this time. They need someone that is responsible for taking care of them on a permanent basis. If the townships think that they can sell the cemeteries, and they are certainly going to be able to do that after they acquire them. But in terms of the court's involvement and certainly my client's involvement, that needs to come to conclusion. And after that, they can do with them what they will. If they think they're marketable, they can market them. We have clear authority under the act to put them in a home, and we submit the home that we selected is the appropriate one. Other than that, if you have questions.
Yeah, I have a couple of questions. So are these cemeteries, either one or both, are they still active? Are there plots that have yet to be filled?
Yes, Your Honor.
I'm sorry, are there plots yet to be sold?
Yes.
So you're in the black now, and so the potential is to stay in the black as long as there's activity maintained properly under the Cemetery Act, correct?
Yes.
Okay, and has there been throughout the years an attempt for a sale to other people who own cemeteries or not?
Yes, Your Honor. The conservator is part of the cemetery owners and funeral home owners groups association, and has made multiple inquiries of those groups to try and find someone that is interested in purchasing these. There's never been interest that they could attract a potential buyer for these.
Right, because they look at how many burials and all of this, there's a whole formula, and they're only interested in the event it's a very active funeral or cemetery. And the other thing is, right, and the other thing is that, and maybe the law changed on this, I didn't look that up, but I don't think that funeral homes can own cemeteries. There was legislation in the past that keeps failing. Is that still the case?
That is still the case.
Yeah, that's what I thought. Okay, and so that becomes also a problem of this. All right, so what is the response on behalf of the townships?
Which township would you like to hear from first, Leonard?
You jumped in, let's hear from you.
All right, so Mike Homer on behalf of Seville Township. And I just want to correct what I believe are some misstatements about Seville Township and Chapel Garden. I had at least 2 meetings with not only Everstory, but also with the AG's office, and requested additional information. In fact, the township didn't know how much was in the perpetual care fund until we got a copy of the petition. And the township took the position that they weren't necessarily opposed to it, but that they did not have enough information, and still do not have enough information to determine what kind of liability this is going to present for its taxpayers. We only recently received the title history for the cemetery itself because here we're separating, it appears, operation and maintenance from ownership. And I'm not sure how that gets resolved at some point, whether the township would have to file some sort of quiet title action to it, whether they should or not. Not to mention the fact that we have no idea what type of liabilities are out there because those have never been shared. We know now that, as stated in the petition, the amount of the perpetual care of $108,000. But in the petition itself, it describes both the endowment fund and all other assets. Well, I don't know what those assets are. So apart from even the perpetual care fund, we have no information about any contractual liabilities or any other assets that may exist. And so the township has not foreclosed it. And to say that they were not interested, I think is just a misstatement. And we conveyed that information both to the AG's office as well as the general counsel for Everstory, and then received the petition. And I think that looking at the act itself, that petition for transfer likely contemplates a willing acceptance of that. What we're talking about here is forced compliance, where the taxpayers of the township likely end up footing the bill in some respect about depending on what liabilities might exist out there. And for that reason, we haven't foreclosed actually the transfer of this, but we definitely need more information to determine what type of liabilities may be lurking out there.
Well, sir, and this would go to both townships, does the statute provide for you to have a choice? Because I don't think so. And if we have, a cemetery is a unique good, it has to be a unique parcel or whatever, we owned in property eons ago, all of us. But it's a unique property and it has certain rights and responsibilities, especially once it's a cemetery. So if the statute provides that it goes to you figure it out. It's not rocket science. The statute provides there is the perpetual care fund, and the rest you're just gonna have to figure out. If we need to clean up title, I guess I can order that and clean it up. I don't know. Do we need to clean up title? Does the conservator know?
Judge, if I may, for Chapel Garden, I believe that there was an earlier quiet title or order of quiet title issued by this court before I was involved in the case, but indicating that the title was intended to be to Indian Nation LLC, which is now a dissolved corporation. But I do believe that action was already taken for Chapel Garden in this case. So it is my understanding based on that order that that issue was resolved.
Okay.
Your Honor, may I jump in on behalf of Albion Township?
Yes.
What's very interesting today is we are learning way more information than whatever the petition provided. We have new facts about burial lots. We have new facts about title search. And the reason we intervened in the first place is because there was such a lack of information that we found it absolutely necessary that there be a discovery period. Because the township, although I want to clarify one thing, the statutes don't necessarily, hey, township, you have a choice. Importantly, the statutes say, court, you have the discretion to make the most informed decision about this petition. And especially now that we have been brought in as parties, we have an opportunity to give this court the most information possible. And as we explained in our brief, to clarify in more detail, this court is not required to grant this petition as it is presented today. Nothing in the statute cited in the petition say that the court is prohibited from exercising some discretion or prescribing certain conditions under which this transfer can take place. The court, yes, is authorized to order the transfer, but you may consider any municipality in which the cemetery is located or within 10 miles of that cemetery. For Albion Township and Albion Memory Gardens, that cemetery abuts the city of Albion and is located within Calhoun County. So nothing compels a transfer to the township. Instead, After sufficient time for fact finding, the court can consider whether there is another municipality who is best suited for this. Because Albion Township in particular is not best suited for this transfer. Yes, we know and understand that there is a duty to take care of particular cemeteries, of all cemeteries in our township. Yet right now we have what is a private cemetery. So we do not have a duty to maintain that. Furthermore, that duty is to maintain, not to assume ownership. Because if this petition is granted, then we would have to assume all obligations, all liabilities, as Mr. Homier talked about. And we would have a really difficult financial situation. Currently, the township is operating under a budget of about $614,000. But the general fund is only $550,000. And about 40% of that goes directly to public safety, the fire department in particular. When we think about taking on ownership of a cemetery, first of all, we don't know the size of this cemetery. The petition is lacking on that detail. We don't know the exact number of lots that are available that could potentially be sold. But when we're thinking about it, after doing a little digging into it, we found out this cemetery is 30 acres. So we found a comparable cemetery, and this is in Exhibit F and G of our motion. And we found that Riverside Cemetery, located in the city of Albion, is about 46 acres, a little bit bigger. But we looked at the city of Albion and we learned that the city appropriates approximately $250,000 to $400,000 annually for the Riverside Cemetery. So it's not unreasonable to think that a 30-acre cemetery will cost on average about $250,000. We don't know what the operating budget of the Albion Memory Gardens is, of course, because we don't have that in the petition. However, when we think about what we could compare it to, not the $93,000 in the endowment and trust funds, that's just not enough. It's not enough to get started. There might be some cleanup costs. It's not enough to buy equipment. The township has never had a cemetery, doesn't have staff for the cemetery, doesn't have equipment to maintain it. And as a result, we are going to have a difficult time figuring out how to modify this budget in order to get it done. Another thing I'd like to draw to the court's attention is the asking for information. When we learned about the possibility of a transfer, we reached out to the AG's office and we talked with Ms. Smith, Mr. Patterson did from our office. She informed us that she didn't have much information about the cemetery's assets, obligations, liabilities, insurance, etc., and encouraged us to reach out to Everstory, the current manager of the cemetery. When we did that, we did not receive a return phone call. We received emails, but unfortunately those emails went to a junk folder. And we did not know that those emails had been sent until this petition was filed. And we noticed and we learned that the township's interests were at risk. What's interesting is that even though 2 emails were sent, there was no other bona fide effort to reach out to us to discuss this or to assist us in getting the information that we need. Because of the lack of information, because we are a now party, we think it premature to act on this petition when the court does not have enough information to really make a decision that is informed.
So are you proposing to bring, what is it, you said Calhoun County is where it actually sits?
It's located in that county, correct?
And it only abuts the township?
And it abuts the city of Albion. So the cemetery is within 10 miles of the city of Albion.
So has anybody talked to Calhoun? So what's Calhoun's position?
We don't know. We have not had an opportunity to subpoena them. Now, as a party, we could subpoena them, of course, and ask them for some information. Based on our understanding, we don't know if the conservators reached out to these eligible municipalities either.
All right, let's ask. Have you reached out to Calhoun? Is one question. The second question I have is, council mentioned equipment, budget, all of those things. If this is transferred, all the equipment, every single thing is going to be transferred. You're not hanging on to things, right?
That's correct, Your Honor. All the
Okay.
assets that belong to the cemetery will go with the transfer.
So have you ever taken the ledgers of the debts, the assets, the equipment, all of that, and provided that to council?
They were told, and Mr. Patterson was specifically told by Ms. Smith, that the financial statements were filed with the state, and he could request it through FOIA, that all he had to do was send her a request back by email and she would send it to him right away. He never did that. And that was over 6 weeks ago, if my memory serves.
Your Honor, that conversation did not happen.
It's in an email. It's in the email that you attached.
Stop!
Sorry, Your Honor.
Is that information, aside from them requesting it from the department, is that in your files?
Yes, we would have whatever equipment is there.
Do you have a list of assets of the cemeteries?
I think we do, Your Honor.
Well, you must. You've been the conservator for all these years. You have a list of the assets, the incoming, outgoing, the debts, all of that, right?
Yes.
How soon can that be transmitted to both council?
I would think within a week.
Okay. And then how long is it going to take you to get Calhoun County involved in this?
I don't know, Your Honor. We haven't.
Not you, Ms. Orange. Ms. Orange. How long are you going to bring them in?
Your Honor, we don't know if we're going to bring them in as a party. It seems very relevant to bring them in because they are an eligible municipality. We would need to enter into a discovery period and potentially subpoena them to get some information from them to see if they might be better suited for this transfer.
Well, it seems to me that I guess I can order them into this case because I get to make this decision. And ultimately, this property has to go somewhere. It can't be held by a conservatory indefinitely. It's already been since 2007. This is incredible. So it has to go somewhere. So whatever other counties are involved, let's get them in, let's get all the discovery out, and we can have a very short turnaround on this. It's not.
I agree with that, Your Honor. Let's get some discovery going on because we need to consider not just the county, but also the city of Albion.
Well, okay. Anybody, any other counties and the other cemetery, is it within your township or does it also sit somewhere else?
It is within Albion Township. Oh, I'm sorry.
And the other one?
Yeah, that it sits within Seville Township. Seville Township is in Gratiot County.
Okay. So in regard to Seville, it's really the only, is it the township or the county that would take it over? Or do you partner together through your funding to do things like this?
The township currently has other cemeteries within the township, and again, I want to make clear, we did not say that we were not going to take it. We just didn't have the information. The township wants to ensure that they have all of the information, and it simply wasn't provided.
Okay, so it's going to be provided within a week. Can you give to council, how long is it going to take for you to give the conservator a list of what you want? Because you're going to take it, I'm going to order that you take it. I don't see any reason why this should not be upheld, but you are entitled to the information and all the property, equipment, data, whatever. Not that you get it through a third party, but that you get it directly through the conservator. So do you have a list of what you want, or shall I just order it transferred, and then if you don't get what you want, you all appear in front of me and I figure out things?
Your Honor, just speaking for Seville, I can put together a list of what we want and get it over to council probably by Monday.
Great, then from that time, you're gonna have, is a week long enough to put that together, and then you can ask me for an extension if for some reason you do not, the information is not available or put together or what have you, I don't know. It should all be there. The way cemeteries are run, it should all be there. It should be easily at your fingertips.
Understood, Your Honor. We will do so.
Okay.
Your Honor, if I can make one more point.
Yeah.
Ms. Smith said that there was a prior order regarding title. Of course, we've never been a party to this case. But as I understood her to say that it had been transferred to Indian Nation LLC, a dissolved LLC. And so I don't want to foreclose any opportunity that if the township, if it's going to be transferred to the township, that would include title to the property itself.
Well, I don't know how it's held. I mean, obviously, I can't believe this hasn't been done all these years, but nonetheless, title needs to be looked at, and then if we need to have orders transferring it to quiet title or what have you, we will take care of that.
Thank you, Your Honor.
Okay, so your congratulations, you just won a cemetery. And you all have a lot of work to do. In regard to, I think the Albion issue is interesting because of how it sits. So how much time do you need?
Albion Township, Your Honor?
Yes.
We would request a discovery period of 60 to 90 days.
Well, Your Honor, the conservatorship we're done on January 19th.
Oh, not if I extend it. Is there some reason you can't go hang on for another 60 days?
Well, we will comply with whatever orders the court gives, but my client is willing to go at 30. I know they would object, for the record, to any longer than 30 days.
Oh, well, I guess they can object to me. Here's what we're gonna do. I'm gonna give you 45 days. I'm gonna split it. You're gonna have 45 days discovery, and you're gonna bring in the city of Albion, or I'm sorry, the Calhoun County, and set whatever matters you want in front of me, and do the discovery, the interrogatories, request for documents, what have you. This, make no mistake, this cemetery is being transferred. It's just a question of to the city of Albion or Calhoun County, however, whatever's in the best interest of everybody. So I can give you some, I think 45 days is more than plenty.
Thank you, Your Honor.
And the conservatorship then will be extended for 60 days from the 19th, and you will all set a hearing in front of me. Within that time period, we'll have a 15 days or so, or whenever you think you have enough of the discovery, set a hearing and let's figure this out. I'm available for conferences, meetings, whatever you all want to do.
Thank you, Your Honor.
All right, so in regard to Seville, you don't really need an extension. How soon? This can be done in a couple of weeks, right?
Well, Your Honor, I think we're going to have to extend to resolve the title issues.
All right, so I'll just extend it so that you start on the paperwork, but in regard to the title, I'm going to expect the conservatorial council to work together for quiet title, and I'm going to give you those 45 days to do that. The conservator needs out. I don't blame them for that. But let's expedite this, and I'm around, so I will fit you into my docket. I can do a call at 6 o'clock at night if you want. I can do it at 6 in the morning if you want. Well, I'll give you my lunch hour. Let's figure this out. And the people who are buried there and the families deserve this as well as all of you. So let's get this done.
We will, Your Honor. Just one more question, and I don't know. We'll have to look into it. As I understand it, the conservator does not hold title either, and so to the extent that it involves this third-party company, I've got to look into what notice or whatever. I mean, if the court's position is you have the authority to transfer or quiet title, I'm fine with that. I just want to make sure that it's done correctly.
Yeah, I think we need to look at the rules there. I'm sure we have to notice them if they are somehow involved. We need to notice them or publish and figure all of that out. But when they don't respond, which I doubt they will, because where have they been? We're gonna quiet title.
Yeah, thank you, Your Honor.
Yeah.
And Your Honor, I assume that once that conservatorship also goes the 60 days as well. So we can get the title all sorted out. Okay.
Yes. So we're gonna get all of that sorted out.
All right, thank you, Your Honor.
All right, and you, who's gonna prepare the orders? I think each township can prepare an order. They're just each a little bit different, so. Anything else?
Not from the conservator.
No,
All right, thank you for your patience with me today, and good education. You got a lot of work to do. I'm here if you need me. That's all for the record. Thank you.
Thank you, Your Honor.
Thank you.
We still haven't seen that structure, so look at it.
So let's find him. Let's get him on.
Mr. Grand?
He's muted.
Yeah, here he comes.
Yes, Your Honor.
Have you found your client?
Well, he's not my client, but
Well, I got it. Well, okay, the person who wants the money.
I reached out and have not been able to get in touch with him. I contacted my client. They were also trying to get in touch with him. Not in your courtroom.
All right. Well, you get this scheduled in the next 30 days or I will deem it abandoned, okay?
We will get it rescheduled. Thank you, Your Honor.